The Committee on Judiciary, to which was referred House Bill 111, an act establishing a cause of action against the state to protect individual rights. Having considered the same, report the same with the recommendation that the bill ought to pass. Representative Paul Birch for the committee. The question before the House is on the Majority Committee report of ought to pass.
Mr. Speaker?
For what reason does the member rise? Representative Griffin.
Mr. Speaker, I rise to make a motion to table HB 111.
Representative Griffin moves that House Bill 111 be laid on the table.
Can we put that on the screen, please, Mr. Speaker?
Yep.
I just panicked that I was moving the wrong motion.
PI? Representative Smith would like to do a PI against.
Judiciary.
Parliamentary.
And so to try smacking it, it doesn't always work, but it's very satisfying. Alrighty. The motion is to lay House Bill 111 on the table. Are you ready for the question? Oh, who requested a roll call? Representative Prout requests a roll call. Is that sufficiently seconded? It is sufficiently seconded. This is a roll call vote. Members, please take your seats.
And if I can speak to the table, Mr. Speaker, please.
Roll call!
Okay. The question is whether to lay House Bill 111 on the table. Representative Griffin is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that HB 111 is not simply establishing a new New Hampshire state cause of action for a violation of state or federal law rights, but is also a bill that turns on its head the current carefully crafted statutory qualified immunity for state and municipal actors employed by and in our communities. And if I know that it does this by eliminating multiple provisions in law, which we now have that provide qualified immunity, which gives agents, employees, or persons such as ourselves, by the way, immunity for decisions, acts, or omissions that are made within the scope of official duties, but the bill doesn't even bother to specify all the statutes that are affected. So this bill needs work before it creates confusion in application. And if I know this is not just duplicating federal law in our state courts, because this law differs in that it requires the individual actor defendant to be named and part of the litigation from start to finish, regardless of who pays, and thus it is always on that person's legal record. And if I also know that this bill never references the laws we currently have, which limit damages that might be recovered in litigation, paid by our taxpayers through our municipalities, and that some members of persons are not even aware such statutes exist, creating an area of confusion in the courts in application, so this bill needs work. And if I also know that this bill applies retroactively, so for example, if a moderator makes a decision in the election place in regard...
The member will suspend for a moment, please.
Thank you.
We're getting to that last, if I know, right?
Yes,
pretty
and
quick.
finally, Mr. Speaker.
There we go.
If I also know that many municipalities throughout the state think that this bill poses a significant threat to New Hampshire citizens and our constituents, and that the mayors of Concord, Berlin, Claremont, Dover, Franklin, Laconia, Lebanon, Portsmouth, Manchester, Nashua, Rochester, Somersworth, and Keene Just yesterday, there's opposition to this bill to the House in writing. Would I now press the green button and table this bill? Thank you.
Thank you. Representative Marjorie Smith is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that the Judiciary Committee, using its usual careful due diligence, voted 19-2 to support this bill, and if I know the language of this bill makes clear that if our public officials are careful in their hiring and careful in their training and careful in their supervision and careful in their accountability, they don't have a blessed thing to worry about. And if I know that the concept of qualified immunity was added on the federal level as recently as 1983 and has been opposed since then because of the problems that have come from saying that public officials are protected from responsibility for their inappropriate actions, and the public has no right for redress of grievances, would I now oppose the tabling motion so that we can hear thoughtful and factually based debate, and then for this body to be able to vote? Thank you.
Thank you. The question before the House is whether to lay House Bill 111 on the table. This is a roll call vote. If you're in favor, you'll be pressing the green 1A button. If you're opposed, you'll be pressing the red 2B button. Voting stations are open for 30 seconds.
Representative Avalani, Representative Belanger, Representative Cushman, Representative Herbert, Representative Lockman, Representative Mason, Representative
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 180 having voted in the affirmative, 188 in the negative. The motion to table fails. The question now before the House is the Majority Committee report of ought to pass. The member from Goffstown, Representative Alexander, is recognized to speak against the committee report.
Thank you, Mr. Speaker. Mr. Speaker, I rise today as a member of the Judiciary Committee to oppose the 19-2 recommendation of OTP for HB 111. To be clear, HB 111 ends qualified immunity. Qualified immunity is the protection in place for municipalities, elected officials, and municipal and government employees against a cause of action that violates a law or a constitutional right. Groups have testified that HB 111 eliminates any defense or immunity in any lawsuit against a municipal or state official or employee, whether brought under federal or state law. It expressly states that it will be no defense in such cases that the official or employee acted in good faith, or that the official or employee reasonably believed that his or her conduct was lawful. In essence, it imposes strict liability on local officials and employees for any injury that results from their conduct, no matter how reasonable the conduct was. If we pass HB 111, we will open up municipalities to a myriad of lawsuits for violations of law. This affects all towns, town boards, and town employees. HB 111 will raise taxes on property taxpayers. Insurance companies love HB 111 because they know their premiums can go up for municipalities because hundreds of lawsuits will result. In fact, because of many of these reasons, the mayors of all 13 New Hampshire cities have sent a letter to the Speaker of the House in opposition to this bill. Finally, HB 111 is anti-law enforcement. I know, and many of my friends, I campaigned on supporting police officers. I stand with my local police department who, in the vast majority of cases, act in good faith and with the best intentions. I urge my colleagues, please vote no on HB 111. Thank you.
Thank you. The member from Hudson, Representative Lakers, is recognized to speak for the committee report.
Thank you. I believe Representative Birch was going to speak first. That's what we sent in.
Mr. Speaker,
I don't have an order. Does it matter?
Representative Birch defends the committee. He gets to go last.
Representative Birch will be going last.
All right. Thank you. I'm rising to speak in support of HB 111. As we heard, one of the most common
Mr. Speaker, I
concerns...
don't mean to interrupt, but if
For
people are...
does the member rise? You can... All good. I apologize. Please continue.
Okay, thank you, Mr. Speaker. As I said, I'm rising to speak in support of HB 111. I think the most common concern that I've heard about this bill, and it's one of the major ones we just heard, is that it will cost government and thus the taxpayers more. I can see two possible reasons for this concern. One is that government employees are believed to be frequently violating people's constitutional rights. I do not believe this is a valid concern. The vast majority of government employees in New Hampshire do their jobs appropriately. However, if that belief were correct, this bill would certainly be needed. And any cost to compensate people for their rights being violated would provide an incentive to fixing the underlying problems that resulted in the rights violations, which I believe actually are not that common. This would benefit both the citizens and the government. Another possible concern is the expectation of frivolous lawsuits that would cost the taxpayers. Again, I believe this concern is unfounded. Lawyers are unlikely to take cases, and most of these will be taken on contingency, that they don't expect to win, and they would earn nothing in those suits. Lawyers could also be sanctioned by the court for filing frivolous suits. We swore an oath to uphold the Constitution of the state of New Hampshire. The first part of that Constitution lists the rights of the people of New Hampshire that this government was instituted to protect. How can we uphold this Constitution if we don't provide effective remedies when rights are violated? This bill would provide that remedy. We are not elected as representatives of the people in order to protect the government from them. We were elected to protect their rights from threats from the government, as well as other threats, criminals and external threats. And Mr. Speaker, I request a roll call vote.
Thank you. The member from Wolfboro, Representative DeShays, is recognized to speak against the committee report.
Thank you, Mr. Speaker. HB 111 will make it only so all cases must go through discovery and possibly to trial. It will force small local governments to make a tough decision, fight these expensive court battles to deter future litigation and prevent an appearance of weakness, or constantly settle out of court and hope this will mitigate the cost and overwhelming burden placed on our communities. We should not place our local governments or our counties and state in such a precarious dilemma. This would be irresponsible. Now, some will say, yes, but currently we cannot hold our government or its employees liable when they violate our constitutional or statutory rights. This is a misunderstanding. The legal doctrine of qualified immunity allows anyone to bring a suit against a government or its agents. The courts then only permit suits where officials violated a clearly established statutory or constitutional right. In 2009, the 10th Circuit Court of Appeals wrote in Pearson versus Callahan, qualified immunity balances two important interests: the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officials from harassment, distraction, and liability when they perform their duties responsibly. The perceived issue we have in New Hampshire lies within our statutory laws. We need to be debating what changes and expansions to our statutory laws that might be necessary to ensure civil liberties are protected. Granted, staters could then use these new laws to show parallels with existing case law and the complementary statutory laws and demonstrate how their rights may have been violated. This alternative solution could even limit the scope of qualified immunity, but in a reasonable way. Ending qualified immunity does not guarantee a building up of case law. It only guarantees an increase in costly lawsuits. In summary, this bill poses an existential threat to our municipal, county, and state governments. It will create extreme fiscal costs for taxpayers. HB 111 will not lead to more guilty verdicts for bad actors who work for the government. The problem is with our statutory laws, not qualified immunity. We shouldn't throw the baby out with the bathwater. The majority of granite staters will lose if this bill is passed, increasing their cost of living and gutting their local municipal budgets. I encourage everyone to vote against the OTP motion and to then vote for the ITL motion. Thank you for your consideration.
Thank you. Does a member yield for a question?
I wave off.
The member does not yield. The member from Guilford, Representative Silver, is recognized to speak for the committee report.
Thank you, Mr. Speaker. Mr. Speaker and colleagues, you may find it somewhat strange that I'm supporting this bill. Normally, I'm on the side of the police and the fire, and I am still on the side of the police and the fire. But I think back to my days in law school when I learned about sovereign immunity, and qualified immunity is nothing more than a variety of sovereign immunity. Sovereign immunity is a concept we inherited from England in 1776, and it arises from the concept in English law that the king can do no wrong. Over 200 years ago, we fought and won a revolutionary war to make sure we didn't have kings, and we still don't have kings. And so we shouldn't be able to hide behind sovereign immunity to shield bad actors. In every other area of civil life in America, when an employee causes damages, the employer is responsible under the legal concept called respondeat superior. Why should we permit the bad acts of employees to go unpunished when their employers are not careful in recruitment, hiring, training, and supervision? And what this bill does is make sure that the individual bad actor is not personally liable for financial damages, but if they do cause by their bad acts damages to citizens through damages to constitutional legal rights, their employers, the municipalities or agencies that employ them, may be held legally liable. And it's designed, as I've said in some of my communications with constituents and lobbyists who are opposing this, I view this bill as designed to put the fear of God into the government agencies so that they are sure and are very careful in their recruitment and training and hiring and supervision of their agents. We should not allow them to hide behind sovereign immunity when our citizens have been damaged. This is the sort of thing that could be covered by insurance, by their liability insurance. The liability insurance premiums may go up, but it won't go up if they're careful. So I urge that this be passed because it needs to protect our citizens from abuse.
Thank you. The member from Wyndham, Representative Lynn, is recognized to speak against the committee report.
Thank you, Mr. Chairman. I've tried to think of maybe the best way to sort of explain my view on this. And I think it's this. This is a small problem, a serious one. I don't mean to suggest that it's not a serious problem, but it's a relatively small problem. And this bill creates a huge, overblown solution that will create more problems than it's worth. But there is a problem in the area of qualified immunity, which, as a number of the prior speakers have indicated, qualified immunity basically says that a state actor, a police officer in particular, is protected from liability if the law is not clear, if the law is not clearly established. And a number of the speakers who have talked before have said, well, constitutional rights, the Fourth Amendment, it says, it protects against unreasonable searches and seizures. Well, certainly, you can read the Fourth Amendment, and that's exactly what it says. But the problem is, if you're a police officer, applying it in the maybe 30 seconds or less that you have to make a decision. How does it apply in this particular circumstance? And that's what qualified immunity is designed to protect, is designed to say that unless a reasonable person in the position of the police officer, and the law takes into account that the police officer is expected to have a reasonable amount of training. But if a reasonable person in the position of the police officer would not have known that the law was clear about what they should or should not do, then we will not hold them personally liable, because we don't want police officers thinking that they have to look over their shoulder constantly before they take action. Am I going to get sued? That's what that's what qualified immunity is about. The problem has developed that some courts, and I don't think that this has been true in New Hampshire, but some courts around the country, and frankly, even the Supreme Court, I think in at least one case or two, has applied qualified immunity unreasonably broadly, so that unless there's a court decision that's like right on point, the officer is excused from liability. And many people, myself included, have said that's just going too far. You shouldn't do that. But that problem can be corrected without eliminating qualified immunity altogether. And I'll just give you an example. As I first heard about this bill moving through the process, which was pretty late in the process, that I actually realized it was kind of going through, and that may be my fault. But at any rate, I happened to speak to one of the proponents of the bill, who are two gentlemen who are from the Institute for Justice. I had this conference call with them and told them my concerns, and they came up with some language that was sort of designed to address my concerns. As it turned out, I thought the language was helpful but didn't go far enough. But what it demonstrated to me is this problem, to the extent that qualified immunity has been applied improperly, it can be corrected without eliminating qualified immunity completely. The only other thing I would say is that there are other problems with this bill which suggest to me that it's really not ready for prime time. And one of them, for example, is the bill says that the bill says the court shall make findings of fact and conclusions of law in every case. Well, okay, there's only one problem with that. Does that juries don't make findings of fact and conclusions of law? They certainly don't make conclusions of law, and they generally don't make findings of fact either. So does that mean that it is the intent of this bill to eliminate jury trials in all of these cases that would now be subject to qualified immunity? I don't think that was the proponent's intent, but that is certainly an argument that could be made from the language of the bill, because juries don't do those kind of things. In short, there are a number of problems with this bill. It's overly broad. The problem can be cured, so to speak, much more in a much more nuanced way that will, I think, address the problem without creating all these dangers that a number of the prior speakers who have spoken against the bill have said. So for those reasons, I hope you will vote it ITL, and hopefully next year we can bring something back that will address the problem. Thank you, Mr. Speaker.
Thank you. Does the member yield for a question?
I do.
The member yields. You may inquire.
Thank you, Mr. Speaker, and thank you, Representative, for taking my question. If we are to assume that this bill, HB 111, is terribly flawed, is there a better way to solve this problem?
I think there is. I think that some language could be crafted for qualified immunity that would basically say to courts, look, yes, you want to have police officers and other municipal officials or state officials protected when the law is not reasonably clear, but reasonably clear doesn't mean that there has to be a case like right on point. You could develop some language that would deal with that and signal to courts, look, you have been applying, or at least some courts have been applying this doctrine so broadly that it protects actions by officers that really are unreasonable, and they should have known was unreasonable.
Thank you.
Thank you.
Question?
Thank you.
Mr.
We
Speaker.
are up to our last speaker and a roll
Mr.
call.
Speaker, can I ask a question?
We're up to our last speaker, and a roll call is requested, so spread the word that we should be getting back to our seats. Does the member yield for a further question? You may inquire.
Thank you, Mr. Speaker. So in a trial by jury, the judge makes determinations of law and the jury makes determinations of fact. So, for example, in the case where an officer is allegedly used excessive force, the civil trial and the criminal trial are separated. Are you saying that with this bill, once it goes to a civil trial, doesn't the officer, if he's going to be sued personally, or even if our individual group of individuals are sued, do they have a constitutional right under the New Hampshire Constitution to a trial by jury and have the facts examined by a jury in a civil case?
Well, that's a very excellent question. I don't think a municipality necessarily would, but an individual officer might well have that right, and that raises the question. If this bill purports to eliminate that right, and it could be construed that way. As I said, I don't know that that's the proponent's intent, but it certainly could be construed that way. Then there's a constitutional question there. If that's what the bill means and it's inconsistent with the Constitution, then the bill is going to fail. I mean, the law would fail for that reason. So that's just another. I guess all I'm saying is that's something that needs to be thought of more carefully than I think it was in this context, which is another reason to have to ITL this and to have it taken up next year.
Follow up?
Will the member yield for one more?
One more.
Wasn't it in the language of this bill that the state actor, the officer themselves, is not included in this? It's just the municipality itself?
The municipality. Well, no. That's the law. The bill says that the officer cannot be held personally liable, but he is entitled to be. But he is to be named as a defendant. Okay. Which presumably means he gets his own counsel separate from the municipality. So the state's going to be paying, or the municipality is going to be paying for two lawyers, not just the municipality's lawyer, but the officer's lawyer, because he's a named defendant, and his interests are not the same as the municipality's interests, because the law specifically says that if the municipality is found liable, the officer can be disciplined. So presumably, because his interests are different, he has the right to his own lawyer, which, again, presumably, that means the municipality is going to pay for that lawyer, too.
All right. Thank you very much.
Thank you.
Thank you. The member from Westmoreland, Representative Birch, is recognized to speak in support of the committee report.
Thank you, Mr. Speaker. And I'm in microphone A4. Mr. Speaker and colleagues, I rise in support of HB 111, voted ought to pass by a 19-2 vote of the House Judiciary Committee. I speak for that bipartisan majority. I'd also like to thank the representative from Hudson for his comments. He has been a true co-prime sponsor from day one on this proposed legislation. I also want to say at the outset that I was a government employee from 1975 to 2009, from before there was qualified immunity until after there was qualified immunity. And I've always been a strong supporter of state, county, and municipal workers. I was one. I've also been a strong supporter of government accountability and transparency. The citizens paid my salary and they always knew that I worked for them. HB 111 is a victims' rights bill. HB 111 is a government accountability bill. HB 111 is a bill that guarantees that the citizens of our state have a right to go to state court for redress of harms done to them by the government, promptly and without delay. This bill is certainly not as complicated as some would make it. An activist Supreme Court tried an experiment in 1982 to provide qualified immunity to protect some government actors. That experiment has been widely considered a failure. Now the U.S. Congress and many states are seeking to end this failure. In fact, on Wednesday, while we were here considering the budget, New Mexico governor signed a bill ending qualified immunity for all government workers in New Mexico called the New Mexico Civil Rights Act. HB 111 does three things. By eliminating qualified immunity, it returns the law to how it was in 1982. It provides a path to state court, in addition to a currently existing route to federal court, to remedy denial of constitutional and statutory rights. And it shifts the burden of any financial penalty and costs from the individual bad actor to his or her governmental employer. I think it helps to return at times to basic principles. The first is something every person in this room probably subscribes to. The citizen is in a higher position than the government. The government works for the citizen, not the other way around. This is a bedrock conservative principle, a bedrock libertarian principle, and a bedrock liberal principle. Basic principle number 2. When the government harms a citizen, the government cannot decide that the citizen has no redress, that the citizen is out of luck, that the government gives itself immunity from the citizen. Our founders in New Hampshire had it exactly right in 1784 when they wrote Part 1, Article 14 of our Constitution. Legal remedies to be free, complete, and prompt. Every subject of this state is entitled to a certain remedy by having recourse to the laws for all injuries he may receive in his person, property, or character, to obtain right and justice freely without being obliged to purchase it, completely and without any denial, promptly and without delay, conformably to the laws. You have heard the argument against HB 111, basically that the sky will fall in if we return to how it was in 1982. That argument was heard and rejected by the House Judiciary Committee by a 19-2 vote. It was not supported by facts. It was not supported by evidence. It was not supported by any history in New Hampshire or elsewhere. And keep in mind, our municipalities, our counties, our state existed for 200 years without qualified immunity, without the sky falling in. And there's no evidence that it will fall in if we return to how it was in 1982. I would like to clarify the issue of good faith and reasonableness. They are not the same. Anyone can claim that they act in good faith. And frankly, the less trained they are, the more valid that point may be. It also produces the game that was referred to by an earlier speaker that is being played out that the exact same facts have never been litigated before, so the conduct is given a pass. And that's been one of the big failures of qualified immunity. The idea that if a plaintiff can't show that the exact same harm was litigated before, the bad actor walks free. What the law requires, and HB 111 does not change, is that the officer must act reasonably. If he or she does, they are not liable. This is current law both from the Supreme Court and the New Hampshire Supreme Court, and it would stay the law. When evaluating whether the conduct of a government employee is unreasonable, a court will determine the reasonableness from the perspective of a reasonable employee and not through hindsight. Not every mistake by an employee is unreasonable. The determination of reasonableness must embody allowance for the fact that employees are sometimes forced to make judgments in circumstances that are unclear about what is necessary in a particular situation. The reasonableness inquiry is an objective one. The question is whether the employee's actions are objectively unreasonable in light of the facts and circumstances confronting the employee, without regard to underlying intent or motivation. And that language is from the United States Supreme Court. Now, I have no quarrel with those who have focused on the potential liability of county and local and state entities who employ or continue to employ people who violate the constitutional rights of citizens. Our county executive committee does our budget in Cheshire County. You're all familiar with how that goes. I've served on the executive committee for 9 years. I currently chair the executive committee. I know much of what there is to know about county budgets. And I know two things. This bill will not cost local governments money. Bad behaving employees will cost government entities money. And if you want to avoid those costs, hire well and train well. We self-insure in Cheshire County, and we put our focus on hiring and training well. A few years ago, I co-sponsored a CACR, a successful effort to amend the New Hampshire Constitution to allow taxpayer suits against the government. I worked with some of the same representatives and the same organizations I work with on this bill. And we heard the exact same argument. If we allow taxpayers to sue the government, the courts and the municipalities will be flooded with lawsuits. The sky will fall in. And you know what? There's been no flood of lawsuits since the Constitution was amended to allow taxpayer suits. There have been no stream of lawsuits, no trickles of lawsuits, barely a drop. But we do know, and what we do know, is citizens are being harmed by bad acting government employees, and those employees in the government agency that hired them are far too often walking away scot-free because of a judicially invented immunity. That offends not only the New Hampshire Constitution, but offends who we are as Granite Staters. The doors of our courts must be kept open to redress wrongs done to our citizens. Please support our citizens by pressing the green button. Thank you.
Thank you. Does the member yield for a question?
No. No, it's pretty late.
The member does not yield. The question before the House is the Majority Committee report of ought to pass on House Bill 111. Representative Tony Lakis requests a roll call vote. Is that sufficiently seconded? It is sufficiently seconded. This will be a roll call vote. Members, please take your seats. Roll call.
Representative Griffin, are you doing a PI?
Alrighty. The question before the House is the Majority Committee report about to pass on House Bill 111. Representative Griffin is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. If I know that HB 111 is based on statutory language drafted out of state, implemented in a number of states, and does not take into account current New Hampshire law, and if I know that an October 2020 review of this law in Virginia concluded that the cost of litigation as a result of the loss of qualified immunity will require reevaluations of policy and funding of risk management for the communities, that operating in a system with a greater chance of litigation will have an adverse effect on the well-being of employees, and that there is the possibility of the lack of response or the use of force being delayed in emergency calls by our citizenry. And if I know that this law can be applied retroactively, so that if at the time a state actor or municipal actor makes an action, it is considered reasonable, but is subsequently found to be unconstitutional, your community would be liable for damages. If I know all that, and having heard the previous discussion, would I now press the red button to defeat the OTP motion so another motion can be made? Thank you.
Thank you. Representative Simpson is recognized for parliamentary inquiry.
Thank you, Mr. Speaker. Mr. Speaker, if I know HB 111 is a victims' rights bill and a government accountability bill, and if I know that our New Hampshire Constitution declared in 1784 that every citizen is entitled to remedy by having recourse to the law for all injuries received, completely and without denial, and if I know that governmental bodies in New Hampshire operated for centuries without qualified immunity, without the sky falling in, and if I believe that conservatives, libertarians, liberals, and Granite Staters all hold dear the principle that government is here to serve the people, and that the government must not evade responsibilities for its actions by claiming immunity from the citizens of this state, then would I press the green button to support the 19-2 bipartisan vote of the House Judiciary Committee. Thank you.
Thank you. This is a roll call vote. If you're in favor of the committee report, you'll be pressing the green 1A button. If you're opposed, you will press the red 2B button. Voting stations are open for 30 seconds.
Representative Avalani, Representative Ayer, Representative Comtois, Representative Edwards, Representative Elliott, Representative Love, Representative Megan Murray, Representative Southworth, are you still here? Representative Yakubovich.
Have all members present had an opportunity to vote? The House will attend to the state of the vote. 178 having voted in the affirmative, 184 in the negative. The motion fails.
Mr. Speaker,
Mr. Speaker,
Who's that?
Rep. Alexander from B3.
For what reason does the member rise?
Because there's been intervening business, I move to lay HB 111 on the table.
Representative Alexander moves to lay House Bill 111 on the table. Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. Well, the ayes certainly have it, and House Bill 111 is laid on the table.
Mr. Speaker,
What reason does the member rise?
I'd like to move that the remarks from the preceding debate be entered into the permanent journal without objection.
I always like to move it that way, too. If, without objection, nice, the remarks will be printed in the permanent journal. I'm sorry, so who made that motion?
Representative Gallagher.
Thank you.